Hello everyone. So welcome to this recording. We are going to discuss about estate planning. Now, what is estate? Estate is something that you pass on to the next generation when you are living or when you once a person dies. Okay? Now there are two parts for estate planning process. First, to pass on something, you need something. So building an estate, that's the first part, and passing your inheritance, that's the second part. Okay? Now, what happens if you don't plan for estate? Don't plan for estate planning means don't do estate planning, don't do anything. So if a person dies without having a will or a trust, then the distribution of asset is decided according to the provincial laws, and it is decided by the court. So it can lead to a lot of frictions in the relationships in your means in your kids or between wife and all those things. So it is best to decide beforehand how you want your own estate to get distributed. Also, if you don't do that, then it's a very costly process to go through the court and the probate and all those things. So it's important to plan your estate, and there are two steps to do it: build your estate and plan for it. With this background, let's start. So, what is your estate? Your estate consists of everything that you own. Estate planning is a definite plan for administration and disposal of one's property during one's lifetime or at one's death. It is There are certain misconceptions that estate planning is only for wealthy. No, it is not. It also includes both building your estate and also transferring your estate upon your death. Used for tax purposes as well as for choosing a guardian for your children and avoiding family fights over your personal belonging. So when you pass on your estate, you have to consider whether your estate is going to pay tax or the person receiving it is going to pay tax when it gets distributed. So either you are going to be taxed at your end or at the person who is beneficiary, he is going to be taxed. So you have to consider that. So what is planning? There are two components of estate planning. First, building your estate through savings, investment and insurance, and then transferring your estate at the person's death in the manner the person has specified. It is implemented by two things: will and a trust. Knowledge in certain areas and good record keeping are extremely helpful when you are planning for your estate. Provincial family laws apply when a person does not have a will. Okay, so getting married will void. Okay, so what is a will? Will is where you decide how your estate is going to be distributed. If you don't do a will, then provincial laws apply. Now different provinces have different laws regarding how the where means how the assets are going to be distributed after a person's death, but there is a common theme is that wife or means the spouse, whether husband or wife, that is currently that is surviving, gets a majority share, and then the shares are distributed within children. Now it gets extremely complicated when you have kids from your previous marriage and you're currently married. Okay, so if you have kids from previous marriage and you're currently married, still the current marriage takes precedence and the wife or husband gets majority of estate, then remaining is distributed. So that is something that you may not want. You want to take care of your kids from your previous marriage also, so it is good to have a will for that reason. Also, getting married and getting divorced will make a will void. So you have to make a new will whenever you get married or you get divorced. So getting married will void a will made prior to being married. Divorce or separation may also affect the validity of all or part of the will. It has an impact on your capacity to order the disposition of will. It is designed to protect those who are financially dependent on you. If you die without a will, your estate is distributed through the legal system. It is costly, and it leads to a lot of family infights, and it is not something that you would want. Opportunity cost of rationalizing. Daily lives gets in a way of thinking about death. So these are some of the reasons why people don't do estate planning. One rationalization is that you are not sure what information you need to provide. Thinking about the outcome of your delay and think through the provisions carefully. Plan in your estate while you are in good health, means when you are of sound mind. Upon death, proof of claims must be provided. Important papers to maintain when a person dies is birth and marriage certificates, legal name changes in case you get married or you change your name, military service record and veteran documents, government benefit documents, because there is surviving clauses in pension. So even the survivors get pension up to a certain age or throughout their life if the provision is there. So it's important to have those documents in place. Insurance policies, safety deposit box records, bank accounts, stocks and bond certificate, and registration of automobile. So all these documents you have to keep it secured and easily accessible. If something happens to you, then they should be easily accessible. Now, what is a will? Will is a legal declaration of person's mind as to how he wants to dispose his property after death. Important point: wills are applicable after death. So if you distribute certain assets in your will, you're not distributing when you are alive. The will takes effect when the person dies. Interstate, if you die without a valid will established, then the province's law of descent and distribution becomes your copy of will. Spouses receive preferential share and the balance is distributed to your dependent. So it can get complicated if you have kids from your previous marriage. Marriage and divorce affects your will, so review your will with an attorney. Marriage may revoke your will. Legal cost to prepare a will vary with how complex it is. A standard cost is around $300 and up, and it does not include living will and power of attorney. So we are going to discuss what is living will and power of attorney in the next slides. So a will requires careful planning to ensure all aspects are covered. So below are certain outlines that you need to have in place. So identification and revocation clause. It identifies who you are, who the will is being prepared for, your residence, and declare that this is your last will, which revokes all previous wills. Okay. Whenever you create new will, the previous wills become invalid, but you have to specifically state that. Then appointment of executor designates the individual or institution you appoint as your executor, may also designate alternative or successive executor if your previous executor cannot act. This clause provides for payment of or compensation to the executor for their services. Executor is someone who executes your will. It can be your family member, it can be your friend, or it can be a professional institution who takes care of that. Okay, so you need to have appointment of executor written in the will. Who is the executor? You have to identify him. Payment of debts directs your executor to pay all your debts such as mortgages, loans, and other funeral and estate administrative expenses. So you have to mention that in the will. Payment of taxes and fees authorizes your executor to pay income tax or probate fees as may be due, because if a person dies middle of the year, still he has to pay tax for whatever time he was earning, right? So that is called as the terminal income tax statement. So the executor has to file that terminal income tax statements upon death. Specific bequests outlines the distribution of specific personal property such as furniture, jewelry, cars, may also refer you to RRSPs, RIFs, and pensions. Legacies direct specific cash payments to be paid if you want to leave legacy or you want to give some donations. Residual estate outlines the distribution of your remaining property after all specific bequest has been made. Trust set out the terms of any trust created by your will. Power clauses enables your executor to exercise various powers in the management of your estate without the approval of courts. Otherwise, if this clause is not there, he needs to get approvals of the court. That becomes a hassle, so you need to include that. Life interest clause used when you want to leave someone the income or the employment of that asset rather than the asset itself. So sometimes you may have family members that are not very responsible, so you may want to provide for them through income, but you may not want to leave that asset to them because you are afraid that they will sell it off and waste the money. So in that case, you can have provisions for that. Encouragement cost used in trust when you want the trustee to be able to give specific life tenant or capital beneficiary additional funds. So emergency funds can be allocated. Survival clause states that beneficiary must survive you for a set period of time before he and she can benefit from your estate. Guardians. So this is extremely important. So you may have minor kids, and if you don't appoint a guardian, then their case goes to the courts, and they may have to be placed in the foster system. Now, if you want to avoid that and someone agrees to take care of them after your death, maybe your family member or your friend, you have to put it in that will. So you have to appoint them as guardians in your will. Unless, means if you don't do that, there is a very high possibility that it goes to the court and the court may decide against the person who wants them. Testimonium and attestation costs. These causes are found at the end of your will. They ensure the legal requirements or validity. So distribution of a person if he dies intestate without a will. So if you have spouse and no children, all goes to spouse. So one common theme across all provinces. There is preferential treatment to the spouse in case a person dies. So if you have spouse and no kids, everything goes to spouse. And this is according to the provincial law. You can change it by having a will. Children only, all goes to the children and it is divided per strip. That is, it is divided equally. Spouse and one kid, 200,000 goes to spouse and rest is split equally between your spouse and the kid. Spouse and children, first 200 to the spouse, then 1/3 goes to the spouse and 2/3 goes to the children, and it is then divided equally. Spouse and relatives, everything goes to your relatives. No spouse or kids, closest next to kin according to the table of relationship. So mother takes precedence, then the father, then uncles, and all those things. Types and format of will. A holographic will, it is a handwritten will you prepare yourself. It does not have any witness and all. Now it is valid according to the court, but it is very difficult to prove. So it is better to have a formal will instead of a holographic will. Holographic will is you have to write the entire will in your handwriting, then you have to initial it. Now there was a famous case in Saskatchewan where a farmer created his will on the back of a truck, right? Because he was in an accident or something. Now court had to approve that will because it is created in his own handwriting and he initialed it. But it is very difficult to prove this in the court. So it's better to have a formal will. Must be written, signed and dated in your handwriting. May not be legal in some provinces and it is difficult to prove. Formal will can be prepared by an attorney, can be typed or be in a pre-printed form. It names the beneficiaries and must be signed and have two witnesses. Notary will, it is available only in Quebec. Now if you create such a will in Quebec, you don't have to go through the probate to prove that this will is valid. Each will has to go through probate, so that where the court proves that that will is valid. But if it is notarized, it doesn't have to do that. Made in the presence of a notary and at least one witness and doesn't require any probate. Beneficiary, it is a person who has been named to receive the property under will. Writing your will, Probate is the legal procedure of providing a valid or proving a valid or an invalid will. Probate courts generally validates will and makes sure your debts are paid. Steps in selecting an executor include the following. So executor is a person who is responsible to execute your will after your death. So find out if an executor is willing to accept this major responsibility, because it is a significant responsibility. Find out if he or she is capable. If you don't name, court will assign one, and then court will have a significant charge for that. So it's better to name an executor in the will. Responsibilities of an executor include prepare an inventory of assets and liabilities, collect any money dues and pay off debts, prepare and file all income and estate tax returns, liquidate and reinvest other assets to pay off debt and provide income for family, distribute estate, and make final accounting to beneficiary. So prepare an inventory, count what you have in assets and liabilities, collect all the money that is due. Means if someone has taken loan from you, then collect anything that is due to you and pay all your debts. Prepare and file all income and estate tax returns. So the final terminal income tax return, the executor has to file it. Liquidate and reinvest other assets to pay off debt and provide income for the family. Then distribute the estate and make final accounting to beneficiaries and the probate court. So little bit more on that. So take initial steps, read and interpret and meet with the family. This is the duties of executor. Become familiar with the deceased financial affairs, communicates with all beneficiary in the will, review insurance required on estate assets, ensure ongoing management of private businesses, redirect mail, cancel subscriptions that you have taken, protect real estate, notify stockholders, bank, business associate of your death, write to bank, trusts, companies, value investment and collect income from them, complete claims for life insurance and company and government pensions, value real estate, cars, households and personal effect, and manage investments, prepare inventory of assets, then instruct solicitor, that is your attorney, to apply for probate, arrange probate of the will. Probate is validity, prove the validity of the will in the court. This also an executor does. Pay probate fees to the court and obtain copies of grant of probate to deal with estate assets. Administer asset, close out bank, brokerage account, safety deposit box and collect insurance proceeds. Register assets in estate's name. Arrange for sale of real estate if required. Advertise for creditors. Deliver household and personal effects bequeathed to the beneficiary. Set off balances to these assets per instruction in the will. Convert assets to cash. Pay off debt and taxes. Prepare and file income tax return. Obtain tax clearance from CRA. Discharge mortgages and other debts. Pay legacies, bequeath and residue of assets, and submit the full accounting finally to beneficiaries. Now, this is a very thorough process, and if you decide to be an executor to someone else, you have to be careful, because you are liable for any mistake that you do. So the beneficiaries can sue an executor if there is negligence on the part of executor. Now the good news is there is insurance for that. So if you decide to be an executor for someone else, it's a good idea for getting an insurance to do it. Okay, so that you are not personally liable for any mistakes that you do while executing a will. Next is guardian. Guardian is someone who takes care of your minor kids. So if you have children, you need a will to name their guardian. A guardian assumes the responsibility for providing the children with personal care and managing the estate for them. Be sure the person is willing to accept the responsibility and their value and child raising practices match yours. Trustee is a person who holds or manages property for the benefit of someone else under a trust agreement. So trustee and guardian are different. Specific requirement of a will: any person over age of majority and of a sound mind can draft their own will, and it is, if you have dependents you should have a will. Testator clearly states full name and residence. A new will renders all formal wills inapplicable. This is important. Name all of your living relatives in the will. Make a list of all assets, valuables, property that you would like people to have, and you must appoint an executor. Now, if you want to change a will, what should you do? If there are significant changes, you have to make a new will and make the previous one invalid. But if there are minor changes, then you can write a codicil. Codicil is an means it's an addition. It appends to the will, to the existing will, and it can change certain small parts of it. Okay, so you can add a codicil, a document that modifies provision in the existing will. Prenuptial agreement. Prenuptial agreement is something that you sign when you get married. So prenuptial agreement is both of you, both of the individuals who are getting married or starting to live in a common law situation, they waive rights to each other's property that was acquired before the union. Whatever you build after the union, you have shares to that, but whatever was brought into the marriage, right, it belongs to the individual. For example, if I have a 1 million worth of house, if my house is valued at 1 million, and if I get married without having a prenup, in that case my house can be shared with my potential partner, even though my potential partner did not have any efforts in building that, right? So if I get a prenup, the 1 million house that I am bringing into the marriage, it belongs to me, but whatever house or assets we build together, that would be shared. Then it agrees on a settlement if you should have a divorce. Now, a living will is a will that applies if you have a terminal illness. So means I have a very close relatives who is undergoing a very tough time. So she is currently in a medical coma, but doctors cannot do anything. She has an illness that cannot be cured. She has been in coma for last 2 years, and there is zero possibility that she is going to wake up from it, and it's like a medically induced death. So she has no senses, no, she's just, her heart is just beating. So you as a person may want means doctors to relieve you from such things, so you may decide to create a living will. Means living will tries to put certain actionables to medical professionals in case such things happens to you. So a living will is a document that enables an individual while well to express the intention that to be allowed life to be allowed to end if he or she becomes terminally ill. Now it is important to consider these things before creating a living will. Discuss your living will with all those close to you and your family doctor. Your family doctor should have a copy with him of your living will. Sign and date it before 2 witnesses. Give copies to those close to you, and it requires careful thought, and you should do a living will when you are of a sound mind. Ethical will. So this will puts in certain conditions. So let's say I want to sponsor my kids education even after my death, right? But I want to pay my kids only if they get an admission into a university. If they decide not to study, that fund doesn't go to them. So such conditions can be put in an ethical will. A document that dispenses emotional and spiritual wealth to the heirs, and you can put some conditions. Now power of attorney is something different. If you get certain medical illness, and if you start suffering to Alzheimer, then you can have a power of attorney. It's a legal document authorizing someone to act on your behalf. Usually, if you become ill or incapacitated, then power of attorney works, and it's important to have that. The reason is, let's say you may not be able to access your banking records, and you may want your spouse or your relatives to handle the finances for you. Now, without a power of attorney, it becomes extremely difficult. So it's better to have a power of attorney in place, and you can put a condition that if I am of unsound mind, then XYZ person takes care of financials. Usually, if you become ill or incapacitated, it applies. Power can be special to carry out certain acts or general to completely act on behalf of you. Conventional power of attorney is automatically revoked in case of legal incapacity, that is in bankruptcy. Letter of last instructions. So this is just a letter you write to your loved ones, and it has no legal bearing. It is not legally enforceable, provides heirs with the information, should include your funeral preferences, name of people you want to be notified, location of safety deposit box and bank accounts, and assets and debt. Now, this was will. The other way to do it is trust. So trust is where you gift your asset to a trustee who handles those assets for the benefit of beneficiaries. So you gift your assets, you give away your assets. Those assets are taken over by a trustee who handles those assets for the benefit of beneficiary. Now that beneficiary can be your spouse, kids, relatives, an endowment, or some NGO, or it can be even you. So you can create a trust that handles money for benefit of you. So trust is a legal arrangement through which a trustee holds your asset for your benefit or that of your beneficiaries. Settler or grantor is you grant assets, so it is the creator of the trust. All trust assets added together are known as the estate. Benefits of trust: it reduces estate tax, avoids the process of probate, frees you from managing assets, provides income for the surviving spouse, ensures property serve as the desired purpose after death. Now, there is one more benefit. Since trust is a separate legal entity from you, if you create a trust and you are not the beneficiary in that, then your creditors cannot sue those assets for you. Example, if I have $100 million in assets, I create a trust of 100 million and I have beneficiary as my spouse, and I am going bankrupt, so I have a lot of loans. So if the creditor sues me, the trust would be treated separately, and my assets that are remaining would be treated separately. So it provides a little benefit from creditors. Types of trust includes living trust or inter vivos trust. It is created and provides benefits while you are alive. Testamentary trust, established by the creator's will that becomes effective on death. And spousal trust, all income from the trust must be paid during spouse's lifetime. Capital cannot be distributed to anyone else during spouse's lifetime. So first is testamentary trust. So assets are protected from beneficiaries' creditors. So creditors cannot touch those assets. That's the benefit. Inheritance are not subject to division upon breakdown of marriage unless one spouse has chosen to share or commingle with them. A testamentary trust can prevent the beneficiary from commingling assets with a spouse. Income earned in testamentary trust used to be taxed at a progressive tax rate, although the trust does not benefit from personal tax credit. As of 2016, all income and realized capital gains held within the trust will be taxed at highest federal tax rate, so they have avoided this loophole. Two exemptions to this rule are graduated rate estate. Testamentary trust will be taxed at the graduated personal rate for the first 36 months after death, at which point it will be then taxed at the highest personal rate. And qualified disability trust will be taxed at the graduated personal tax rate provided the beneficiary qualifies for disability tax credit. So it means when you create a trust, it is generally taxed at the beneficiary's end. But the government has a rule: if you create a trust for a non income generating member, so they will have a lower tax bracket than what you have. So to avoid this splitting of income, generally it is taxed at the highest tax rate unless and until the beneficiary is disabled. Income splitting of trust income in case of multiple beneficiaries is still a major advantage for this type of trust. Remember, the income can be distributed to beneficiaries via T3 income and taxed at their marginal rate. Spousal trust: the beneficiary spouse needs guidance in financial management. That's a very valid reason to create one. The deceased wishes to provide for the surviving spouse in the second marriage but wishes to pass the assets from the first marriage. So in that case, you can create a trust. For the kids, the deceased wishes to avoid the double probate of assets, once in the hand of deceased and the second time upon the death of surviving spouse who has received the assets outright. Pros and cons of trust: renders need to probate redundant. It is more private because when you do a bill, you have to do a probate, so it goes in the court and everyone knows about it. Trusts are much more private. It is easier to change terms. Trustee has an authority to manage assets in the event you become disabled. Cons of it is must be properly funded. Cost of attorney to set up a trust is higher than a will. Still, you need a last will and a testament. Longer time is allowed for contesting a trust. So when you create an estate, make an inventory of your estate, which includes cash, bank account, GICs, money market funds, stocks, bonds, mutual funds, life insurance companies, life insurances that you have, employee benefits and annuities, your homes and other real estate, business and farm interest, corporate interest, partnerships, interest and trust and receivables, and antiques, arts, collection, cars, etc. Now, some assets are not distributed according to the will. These assets have nominees, and nominees take precedence over the will. So, life insurance, annuities, and RRSPs goes directly to the named beneficiary instead of distributing according to the will. If you don't have a beneficiary, then it will be distributed according to the will. Asset held in joint tenancy confirms the right of survivalship. Life insurance and employee benefits, so free of income tax and they are excluded from probate. Lifetime gifts and trust are also excluded from distribution according to will. Settling your estate: if you have a will, the executor will carry out your wishes. Probate and administrative costs: the fees of attorney, accountant, appraiser, executors and administrators are in the range of 3 to 5% of your estate. Probate cost rises with the size of estate. If you die intestate, your estate is distributed according to provincial law under the control of court appointed administrator. So that's it with estate planning. This ends the personal financial planning sessions. Thank you and have a nice time.